Supreme Court by a 4-1 majority decision has dismissed 2 applications challenging the ongoing processes to possibly remove suspended Chief Justice Torkornoo from office. The first suit was brought by the Center for Citizenship, Constitutional and Electoral Systems against President Mahama's suspension of Torkornoo, seeking to invalidate the suspension and the ongoing probe by the 5-member Presidential Committee on the petitions against the Chief Justice. Census contended that President Mahama's actions were unconstitutional, asserting that the suspension of the Chief Justice and the establishment of a 5-member committee to investigate allegations against her contravene provisions of the 1992 Constitution. The Supreme Court panel, led by Justice Paul Bafo-Boni, with Justices Isifu Umoro Tanko-Amadou, Yoni Kolendi and Henry Anthony Boache, upholding the President's authority to take the actions in question, affirming that due process had been followed, while Justice Yao Asare Dako dissented. Details of the ruling will be available, according to the court, on the 29th of May. So that was the first position today. The second one, also by a majority 4-1 decision, same persons upholding and then one dissenting, they dismissed a second application brought before it by a private citizen, Theodore Kofi Atakwoti, challenging the process to possibly remove the suspended Chief Justice Torkornoo from office. The application was deemed by the court unmeritorious and subsequently dismissed today. Now, the plaintiff had requested the Apex Court to place an interlocutory injunction on the work of the Committee of Inquiry established under Article 146 of the Constitution until his suit was fully determined. The application also sought to suspend the operation of the President's warrant of suspension issued under Article 146(10)(a), which led to the Chief Justice's temporary removal from office on April 22, 2025. Now, amongst other reliefs the applicant was seeking is also a declaration that under Article 23(1466) and 296(b) and (c) of the Constitution, the President's discretionary authority to determine the existence of a prima facie case for removing the Chief Justice must be regulated by a published constitutional instrument. A declaration that the Council of State's advisory role in such matters must also be governed by a transparent and codified process subject to a constitutional instrument. The third relief he was seeking was a declaration that the Committee of Inquiry's proceedings under Article 1466 must follow clearly defined procedures, powers and limitations set out in a constitutional instrument. And finally, an order nullifying all proceedings related to the removal petitions, including the President's prima facie determination, the suspension of the Chief Justice and the formation of the Inquiry Committee on grounds that they violate Articles 296(c) and 11(7) of the Constitution. So this brings to 3 the number of petitions against the process so far. The first one was by Member of Parliament for Ota for Eko Vincent Asefua, which the Supreme Court by majority 4-3 decision dismissed, and today 2 petitions 4-1, both majority dismissing. So what clearly does this mean? So it means that what? The committee can go ahead with the proceedings. Let's get a better perspective of this. Theophilos Jimega Jr. is a private legal practitioner and he joins us via Zoom. Good evening to you, Counsel. Thank you for your time on 505. Counsel, can you please unmute for me? I can hear you now. So I'm sure by now you know this. So this petition, one will say maybe the petitioner should have taken a cue from what happened to the Vincent Asefua matter. Dismissed these, that was 4-3. Now we have 4-1 in both cases. What's your readings into the decision by the Supreme Court today?
Also filed another application, an injunction application today, for it to be heard very soon, and the same matter. I think it is time the Supreme Court rises and say that, well, we have dealt with this. If you bring similar thing, we will award costs, and the cost should be borne by the lawyer. I think that will serve as a deterrent. Indeed, the Supreme Court cannot sack anybody from the altar of justice. Everybody is entitled to come. But if these are like repeated applications every day, and it's a strategy to frustrate the work of the committee, then the Supreme Court must do something. Indeed, I also felt that the application bordering on, can you hear me, Val?
I can hear you loud and clear.
Yes, the application bordering on the use of constitutional instrument has been dealt with in, at least, if we count the cases 4 cases, but 3 of such cases were consolidated. The Nana Bedeto Agbemava cases were consolidated. That was on the Muntie thread that the president should have published a CI. Then there was the Ransford France application too, where the Supreme Court dealt with this extensively to say it is needless for the president to go and do this. Where in the Constitution do we have that the duty of the the Council of State has to be codified? To say it has to be codified means it has to be in a document like a code or has to be a law.
Codified subject to a constitutional instrument. That's what they're saying.
Yes, we need to do that before this process goes. And listen, if they suspend you and codification will take a further 3 months for the codification to come to pass, you are indirectly dismissed. You cannot be in suspension in perpetuity. So I don't know what went into the thinking of the application as they currently are doing it. Okay. I think it is time the Supreme Court comes to say, hey, we have dealt with this before. To bring such an application, we award a heavy cost. You can come. We are okay. Come over. But we award a heavy cost if we are not able to convince us.
But and remember, but surprisingly, before you even continue, this is the same position that the Ghana Bar Association was holding. The fact that they say the president is not a judge or a worker of the court, so that suspension should have been done by an instrument. You recall that's what's the position of the Ghana Bar Association?
Yes, I'm a member of the Ghana Bar Association, but let me be honest here to say that you saw the backlash the so-called Ghana Bar Association resolution received. The position of the law is that judges cannot close their eyes to happenings in society. So whatever is happening in society, the judges know. They are part of us. Some are church members with us, some are choir members, etc. They know. The thing Ghana Bar Association purportedly did was wrong, and they saw the backlash. You think that Ghana Bar Association would not have gone to court, would just have issued a resolution and leave it there? They would have gone to court. But they knew that they would lose. Now, this again, as I said, the Ghana Bar Association, and in Linsod addressing that position, made it clear that the Supreme Court has made rulings. And indeed, the Supreme Court said each time the president wants to issue or to take a discretionary decision, has to go to parliament, will lead to a nuclear meltdown. That is not what we want now. So I think that, look, it's a coordinated strategy. I understand someone has filed again to injunct the members. Can you believe that you sued and sued even the members of the committee from sitting down? They've just been appointed. They've just been appointed to do a statutory duty. So once they do their statutory duty, they are gone. So, and you cannot put the, let me use local man's balance, son in Gary of a statutory body from performing their task. That no court will condone or welcome you with. So for me, I think that this is much ado about nothing. It's a coordinated effort to try and stop the process. But again, let's wait for the ruling. Let's see the reasoning of my lords as to why they went that way. But where I sit now, I wasn't expecting any other outcome.
Again, we'll talk about the new one that has been filed, and then why you think there's this coordinated effort to quote unquote delay this and what the ramifications will be. But the final relief the private citizen was seeking, which I want you to explain to us, is an order nullifying all proceedings related to the removal petitions. That's including the president's prima facie determination, the suspension of the Chief Justice, and formation of the inquiry committee on grounds that they violate Articles 296C and 11.7 of the Constitution. Is there any violation here? Articles 296C and 11.7 of the Constitution.
all this had been dealt with in the cases I cited earlier. But I want to take listeners through a bit of tuition. For you to seek an injunction, you must have a right either at law or at equity, for which you want the law to protect. And for this reason, the persons are going on under the provision that a constitutional provision has been violated. So in effect, they have a right that they want the Supreme Court to protect for them. And injunction applications, discretionary remedies being sought. So it's at the discretion of the judges to give this injunction. The judges in a number of cases, at least 2 or 3, last week, somebody withdrew his application to the Supreme Court when the others were not going properly. So why won't you take a cue from that and say that there have been 3 attempts already, they have not been successful? What is it that you are bringing in now? Now you are saying that the same president who has formed a committee, that you are challenging the committee, the president should now form another committee or commission to investigate what he has done wrongly. My Lord, where have you heard that from? It can never happen. It's the same president you are talking about. And indeed, the president thinks like the petitioners or the applicants. The president is a human being just like them. So the president cannot yield to that. And the president has a good counsel. There are counsel in the office of the president. There's the attorney general and his deputy. And there are also NDC lawyers and leads, etc., that will advise the president. So where are they getting this from? That will not fly. That is why I am of the view that this is a coordinated effort. Look, let me tell you, the next thing that we are going to have is that we are going to have an application for review.
Review of all the decisions that have been done?
Yes. That is what is going to happen. And you know, the purpose of the review is that they might be thinking currently, these judges might not be favorable to us or sympathetic to us. So let's go for review, where they might add others which might be favorable or listen to us favorably. Then that will also stall the process for a while. You see, that is why I am very, very sure as an engineer that this is a coordinated, not just as a lawyer, this is a coordinated effort to stall the process.
Okay. In stalling the process, the Chief Justice still remains suspended. And there's an acting Chief Justice. So even if they are stalling, it doesn't negate the fact that the suspension has been carried out and there's an acting Chief Justice. And even if, depending on how long they are going to stall this, even if the acting Chief Justice's time at the bench elapses, the most senior will still become the acting. So then the person you think you want to protect and ensure she comes back to work will still be on suspension whilst you are still stalling this process that we could have used like 3 or 4 months to deal with. Who then are we punishing?
Good. I love your last word, punishing. So you see, in effect, after a while, they might come up to say that the suspension has taken so long, which in effect is similar to dismissing the Chief Justice wrongly. Okay? Because if the Chief Justice is on suspension for 6 months to a year, then you will say, no, this is no more a suspension. This is a dismissal or removal in the wrong way. So come on, reverse that and reinstate her. That is the ultimate they are trying to play to. That's why I'm going to, that is a coordinated effort to delay it. Then after a while to say that, hey, you have kept this lady so long and it's akin to remove her, and you have removed her wrongly.
But that suspension would be subject to the final determination of that committee, and the committee has not started work. So how do you then bring her back when the committee has not finised the work to determine whether she's free or not?
Sorry to interrupt you. Sorry to interject. What I'm trying to say is, for example, if your employer should suspend you now and you stay at home for a year or 2, you can come back to say, you have in effect dismissed me. Because how can you suspend me for a year? That's the sort of things I'm talking about. That they are going to say that, hey, you have kept her away for a year. That is removal in effect. But you didn't follow right process. So reverse the removal. I hope I've made sense to you.
Yes,
that's the sort of thing. So you could, if your employer should suspend you, you've been at home a year and a half.
But suspending me will be subject to something, that there's a committee investigating something.
Yes,
if
and the committee has not. So if all this process is stalled and the committee is not working, and which is not the doing of the suspended CJ, then she can say it's not my doing. You did it, and I am here. So come on, you are violating my right. Reinstate me. Okay. That's why I said they are trying to drive her. But you see, currently, what phrase can you hear in the country? The law is the law. Let us allow the process. It doesn't mean the suspension. Are they afraid that the Chief Justice suspended might not come back? Allow her. She might have a watertight defense. Let her go and present her defense. She's exonerated. She comes back. And we all move on smoothly. I don't know why they are a bit jittery. No, let's allow the process. Except those going to the Supreme Court don't themselves trust the process.
Okay. So I have news that has just come in that the suspended Chief Justice herself has personally issued a writ against the Attorney General and 5 others. She's seeking, among other reliefs, to stop the committee from sitting tomorrow morning. She's also filed an injunction application.
Well, as I told you, I heard somewhere that someone has filed. Thank you for drawing my attention that it was the suspended Chief Justice who has filed. Now, you know, there are 2 schools of thought. One says that once an injunction application is filed, it is as good as if the application itself has given. One school says that it is filed, forget about it. But looking at how high the stakes are in this matter, if that application is brought to the notice of the Attorney General and the 5 others, I'm sure the committee will not see tomorrow. Even if the committee says that we have not received it and they want to see it, the suspended Chief Justice herself will not appear. So there's no point the committee sees. Now, we don't know the details, what reliefs she's seeking in the application. We have spent about 10 minutes talking about those ahead of her. As my late dad would say, the character of the dead is a lesson to the living. What else will she get apart from what others have gotten ahead of her? Tomorrow is heavily pregnant, as Judgement will always say. Today we have a suspended Chief Justice going before her colleagues, asking them to do something that, in my opinion, might not be right. It's going to be very difficult for her to get anything out of it. Because those before her haven't gotten anything out of it. Respectfully, if I were her lawyer, I would go. Because those ahead of us haven't gotten anything. What is she going to get? What arguments is she going to make that those ahead have not made already? And today, I understand that her lawyer was also in court and sided with the first applicants to say that she
associates herself with
he associates himself with what the application. So what else is it different from the one he has the opportunity today to have articulated all the points? Indeed, he could have filed an affidavit to support and articulate all his points. Or he could have spoken on points of law today, but he just said he associates himself. Then another day, you go and raise more. And the one you associated yourself with has been dismissed. Then you are now going to do what next? It beats my mind. But again, as my senior says, Judgement says, tomorrow is heavily pregnant. Well, let's allow tomorrow to see what comes out.
What can the Supreme Court do in the face of all these injunction applications to prevent a further delay of this process?
You see, the going to court is a constitutional right. You cannot stop anybody from coming to court. No, you cannot do that. That in itself will be grounds for somebody to go to court. So you have to allow everybody to come to the altar of justice. However, the court also has the discretion to award costs for unmeritorious and frivolous applications. Perhaps the court needs to start to do that. But you see, the stakes are high. So the court too doesn't want to appear to be one that is preventing people from coming to court. That is why they're doing it. But I believe we are getting to a stage where the applications are made and the Supreme Court will award costs heavily against the applicants and ask the lawyers to pay for it.
Well, we'll see how this case goes from tomorrow. Very grateful that you